Got a lot to talk about and all the developments out there. Let's bring in my think tank tonight. Joining us in Vista, California, criminal defense attorney R.J. Manuelian, criminal defense attorney Barbara Moon in studio with me, criminal defense attorney, former law enforcement officer Lance LaRusso is with us, and criminal defense attorney Ashley McMahan. Welcome to you all. R.J., I'm going to go around the horn here quickly just to get a baseline feel for everyone. The fact that they want to hear from Jane Doe number 4 and her friend Nicole Edwards again, from your perspective, in like a one sentence, who is it better for and why? RJ?
I think it's better for the defense in this. Yes, I think it's better for the defense in this case because they're not decided. Obviously, if they were decided, they wouldn't need readback. So that's a good sign. They're not completely convinced that the evidence has been proven beyond a reasonable doubt. So that's a win for the defense at this point.
All right, Barbara Moon, do you agree?
I do agree, because I think if there's any inconsistencies they're looking for, like there was one witness who said that she said it happened in a car, and so I think if they're looking for any inconsistencies, and they're struggling, and they have not decided yet that anything's been proven beyond a reasonable doubt. So I'm thinking the defense.
Lance LaRusso.
Well, it's interesting. Sometimes they want to hear it because there's inconsistencies among jurors. So when they get back there's a reason the door's closed. They argue with each other. And sometimes you know from talking to them afterwards that they were heated discussions. So they may ask for a readback just because juror number 5 says, no, that's definitely not what they said. And juror number 6 says, no, we're going to ask for a readback because I heard it differently.
All right, Ashley McMahan, who do you think is better for at this point?
I'm going to go with the defense. I absolutely think it's better for the defense if they were absolutely convinced that Jane Doe number 4's testimony was so compelling at the time they wouldn't need a readback. And also, we've discussed that each one of these individual cases is not very strong on its own. It's only in culmination that it looks kind of bad for the defendant in this case. I think individually they're struggling with each individual Jane Doe as they go down the line.
All right, it's going to be a battle tonight, folks, because I disagree with every one of them tonight. And the reason being is what these text messages were back and forth between Nicole Edwards and her friend Jane Doe number 4, because they were talking about what happened. From my perspective, it's two friends. It's getting inside that conversation between two friends about why they're coming forward at this point. So let's take a look at those text messages if we could. Just to give everyone a better flavor for what's happening here. All right, it begins with Jane Doe number 4 saying, never said anything because I thought it was always my fault. But I remember screaming, no, no, I can't, Nikki. This is truly bringing me to tears and freaking me out. Nikki Edwards, I do remember. I hated that we never said anything. I'm so glad they finally got him. Jane Doe number 4, you have no idea the feelings I'm having right now. Nikki Edwards, her friend, I'm so sorry. Then Jane Doe number 4, thanks, Nikki. I just needed to share this with you. It's been something that has messed me up for so long. Then Nikki Edwards says, when I first heard of it, I was happy. They got him, bleep him, but I wasn't sure if I should have reached out to you. Didn't want to bring up those memories. How do you feel now? Jane Doe number 4, oh, no worries. I totally understand. I just saw it this morning and started crying. I'm happy they caught him, but I feel so sorry for his wife and children. Jane Doe number 4, I just hope they have enough to hold him, because I was reading another article that they're trying to blame this on a brain injury, which is bull, because he was doing this bleep before he was in the NFL. Nikki Edwards, of course they are, and I'm sure a part of his brain injury, but he's still guilty. Can't let him go and go risk him doing this to someone else. Jane Doe, for sure. Jane Doe 4. Remember his friend Chris? Well, his mom was my mom's friend that she was living with her last year of her life. It was so hard being there, not just because I was losing my mom, but every photo in her house had Kellen in it. And when I was with Chris, I knew he remembered what happened. Jane Doe number 4, his mom always reaches out and I'll chat with her, but when she would talk about how proud she was of Kellen, I get so upset inside. Now, I took some time to read that, folks, to give you the flavor of why I'm thinking maybe, just maybe, they're focusing in on this, trying to get inside the mind of, because the question, right, with Jane Doe number 4 is, why now? Why is she really coming forward? Let me bring back in the think tank now. All right, RJ, let me go back out to you. Did I change your mind at all?
No, I think Mark Carlos hit the nail on the head. I think he's right in telling the jury this is a money grab. Jane Doe number 4 waited so long, and she was so inconsistent with her statements. She told the story of her testimony one way, and in her friend, when she testified, Miss Edwards, she said she remembered half the things that she said, and they weren't consistent. So I think the text messages may bolster somewhat the prosecution's theory, but ultimately I think the testimony of Jane Doe number 4 collapses.
All right. Is there anyone that agrees with me? You don't have to, but is there anyone here tonight that, no? Okay.
I think the texts actually are pretty telling, because you know that when you talk about the credibility of a witness, when you have testimony that they get to say or words that they've said when no one's watching, and as you said, it's between two friends, that could be very powerful to a jury. Nobody was watching, nobody was asking questions. For all they knew, of course, everything on the internet is completely private. So for all they knew, no one would ever see these texts. So there's a certain indicia of reliability that I think the average person would assign to it.
But there's also the idea that maybe somebody would see these texts eventually. And obviously these text messages are happening close in time to the trial. They're not happening in 2003. They're happening now. So I think it works just as evenly for the defense to say, hey, maybe these two got together and planned this, and now they're giving their own testimony without really giving testimony to bolster their statements from something that they're claiming happened in 2003.
Well, the delay obviously is a big problem here. So you could be thinking that she's wanting this publicity. That could be an issue. Could be a money grab, which goes along with this theory, and maybe a possible lawsuit down the road. So you can focus on those as well. But for the prosecution, you can also think, well, this bolsters her testimony, because it does sound kind of natural, you know, that she's sad, that she's upset. This brings back a lot of memories. They finally got him. So when you hear that, it's pretty natural between two friends, you would think, that they're venting and kind
Absolutely. Now, do we all agree that something happened? And I'm not saying a rape, but something happened between these two, right?
Well, she admitted in her testimony that they had consensual sex prior to the alleged rape incident. So, I mean, even in her own testimony, we would know that there's some sort of relation there. And also, defense counsel really hammered her on cross about the fact that she willingly got into the car with Winslow and his friend, I believe his name was Matt, who was the one that she claimed made her uncomfortable before she was ever intoxicated before the alleged second rape happened. So I think the jury's going to hear that and think, well, that's a little odd, you know, if you had an uncomfortable sexual encounter with these two individuals, why would you willingly get into the vehicle with them just a week later, and now all of a sudden you're saying a rape occurred that evening?
You're 17. I mean, that's one of the reasons she explained that I'm 17. No one's going to believe me. That's why I didn't report it, right? And let's be honest now. Do you think she would have been, RJ, do you think she would have been believed when she was 17 years old if she came forward with this, a 17-year-old who was drinking? Do you think she would have been believed back in 2003? Or is she right to believe that people would not have believed her back then?
I think it would have been more believable if she brought the fresh complaint as opposed to waiting. As you know, Vinny, the longer you wait, the more questionable your version of events becomes. And a defense attorney like me would have a field day in cross-examining somebody about why they didn't come sooner. So to that extent, I disagree with you. I think if she brought it earlier, it would have been better.
Well, hey, all right, I'm going to go around the horn on that question about the cross-examination. Barbara Moon, cross-examining a 17-year-old back in 2003, or a woman who is now, you know, in her 30s, is a mom, you know, which one would you have more of a field day with?
Well, with the 17-year-old, because why is she going back the second time to get in the car with someone 2 weeks later when she had this unpleasant experience having sex, consensual sex, that she admits, and that Matt comes in the room and wants to watch? That's got to be very uncomfortable. Then she's at this station and her girlfriend goes off to another party and she hops in the car with the two people that she just said 2 weeks ago she's very uncomfortable with. How does she know this same occurrence is not going to reoccur?
I think she would have had a much more difficult time as a 17-year-old, right? I mean, it's tough enough testifying, it's tough enough talking about this stuff as a 17-year-old girl, not a woman, girl. She's 17 years old.
Yeah.
What would that cross-examination have been like back in 2003?
I definitely think you've got to treat it with kid gloves. You got a very vulnerable witness or victim on the stand. She's young, she's impressionable. She's probably, just as you said, Vinnie, not very willing to come forward and testify about this, especially if she's got to admit that she was partly involved. And there's a lot of victim blaming that goes on in this. You know, I don't know if I said no. I do remember saying no, but then she's not sure. I don't know if part of this is my fault, if she led them on. I mean, she even indicated that as an adult. Obviously, this is questions that she's still struggling with as an adult now. I think it would have been even that much more difficult to cross-examine her as a 17-year-old. But I'm telling you, if she came forward early and this was just the only case that they tried against him at that point in time, I think it would have been a slam dunk for the defense. I don't think prosecution would have won.
Lance, do you think where we are now in society, where I think there's more understanding generally among the public about, you know, women can come forward many years later and be telling the truth? Do you think that helps in this case, or does it really have no impact once you get inside a courtroom?
Well, I think there's two parts of that. So first of all, when you talk about the 17-year-olds make mistakes. Kids make mistakes. So that would be something a jury may be willing to forgive. And when you have somebody with a gap of time, you can always cross-examine on the gap of time because memories fade, details fade, and the less details you have about something, the more you have, it's ripe for cross-examination. The problem is we have more educated jurors about these issues today. There's more play about people having memories that come back, or people coming forward after, you know, a significant event has occurred, or they've seen another trial, or something happens to their child and they say, well, you know, this grandfather actually molested me too, but I was younger. So, you know, when the jury's understanding that, I think they're probably more willing to forgive that gap in time. And as a defense attorney, you better not put all your eggs in that basket, because you can really get somebody mad at you.
Absolutely. Hey, folks, want to hear from you as well. You heard from some of the experts. They'll be with us the whole show. Our 13th juror question. The jury, as you know, wants to hear the testimony of Jane Doe number 4 again. They've been listening to it. Is that better for the prosecution or defense? Go to our Facebook page, vote, let me know, put a comment down there in the bottom section, and we'll reveal the results at the end of the show.
What was it about your husband and Nicole's support that led you to decide to call the sheriff's department?
It actually wasn't even them two. It was my kids.
What was it about your children that caused you to call the sheriff's department?
I look at 2 innocent girls and never would want them to ever feel like they didn't have a voice, that it was not okay, or that it's okay to say no and to be able to speak up and tell their truths.
That is Jane Doe number 4 telling the jury why she came forward with these allegations, why she made that call after seeing that Kellen Winslow had been arrested, why she came forward 16 years later, 15 years later. All right, a lot happened today, the readback of Jane Doe number 4. Let's go to San Diego County, California. And there she is, Charlie Painter, our correspondent, was inside the courtroom all day for this readback. Chanley, first question. Whenever there's a readback, I am very interested if there's any moment during that readback when all of a sudden there's some sort of reaction by the jury. Either they're looking at each other, or they begin to write something down, or kind of nod their heads to each other. Did that moment happen today?
Mm-hmm. Well, Vinnie, I was able to glean some indications, and you can take them as you want to take them, but this is what I noticed from this jury. They file into the courtroom, the defendants at the defendant's table, Kellen Winslow II with his attorneys, everyone stands up as they enter. I noticed first thing, no one is looking at the defendant or the defendant's table on the jury. As they sit down, juror number 12 does look over at the defendant's table, and then as the reporter starts to read the direct examination, the jurors seem to be sitting up, and they're taking ferocious notes through most of the questions concerning what happened the night that Jane Doe number 4 alleges Kellen Winslow raped her. They take notes leading up to that night, so maybe the night 2 weeks before of the consensual sex encounter, and then the night of the alleged rape. They're taking a lot of notes throughout this, and then I noticed that it pretty much slows down throughout the last hour or so of her direct testimony. Then we take a break this afternoon. The jury gets to kind of get out in the hallway, take a restroom break, come back in the courtroom, and then the reporter reads the cross-examination of Jane Doe number 4. Noticeable difference in the jury. They mostly are sitting there just relaxed in their seat listening. Not as many notes being taken by the jury except for a couple, number 2 and number 12 more so, very much taking notes during the cross-examination of Jane Doe number 4. And again, not many people looking around. They're just mostly looking at the court reporter, and that lasted through about 4:30 almost, so until they ended the day at court. And those are my main observations, Vinnie.
All right, and how do they look? Did they look tired at all? Do they look like they've been through a battle, or do they look pretty similar to the way they've looked throughout, which is, generally attentive, relaxed, and ready to go?
They look pretty tired to me, for the most part. They are attentive still, again, taking a lot of notes in certain points of this testimony, but I was seeing a couple of yawns among the jurors. It's been a long day of deliberation for them, it looks like, and you can see there's a little separation. A couple of them aren't as friendly anymore. Maybe there's some tension there, and I think that it happens when you're debating and deliberations all day long. But they did seem a little bit exhausted. I'm sure they're probably ready to end the day pretty soon.
All right, Chanley, another big development today was that we found out who the foreperson is of this jury. Number 6, right?
We did. Right, juror number 6, and this is pretty much what we were thinking because he signed both of the notes, the note from yesterday and the note today for the jury, and he did confirm that he is the foreperson. He's probably in his 30s. He is the COO of a school. I have a little information about him here. It's a summer educational operation. He's a COO of that. He employs 10 people. There's 150 seasonal employees that he manages, and his wife's a chemist, and he has a friend that's in law enforcement. These were all answers that he gave during voir dire week, so this is kind of how we can get to know him a little bit better, but he did answer the question about the Me Too movement, and he said he thinks the Me Too helps support and comfort women coming forward, but doesn't mean allegations are always true. So those are little tidbits we have about the foreperson, juror number 6.
And is he one of the youngest on this jury? Because I know the way the jury's been described to us here, 8 men, 4 women, and we sort of skew a little bit older, not old, but older, right? Kind of like my age and a little bit older.
I'd never call you old, Vinnie. But yes, he is one of the younger. So there are 8 men and 4 women, and two of the men, actually, let's see, 1, 2, 3 of the men are younger. They're probably all late 20s and 30s, I would guess, around the same age. And he's one of the younger men. There's, of the 4 women, 1 is younger and probably in her 20s, but the others, all the rest, men and women, are 50s and 60s, Vinnie.
All right, a lot of information. So they're coming back tomorrow, but they're going to deliberate before they finish the readbacks, right?
They are deliberating right now, as far as we know, unless we have any updates from inside the courthouse, but still deliberating. And the judge said, "Do you want to go back?" They said yes. The foreperson said yes. We have some stuff to talk about, so they were going to go back and deliberate. They're going to be back tomorrow around 9 a.m. But this judge has some other items he needs to take care of in his courtroom around 9 a.m. So we'll probably get started with the readback around 9:30 Pacific time tomorrow here at the courthouse, and they'll continue the cross-examination and then go on to Nicole Edwards' testimony.
All right, and what's the timing of all this, right? Because today it took several hours to read all of this testimony. Nicole Edwards' testimony was much shorter.
It is. It's probably around 22 minutes or so, her testimony is, and I believe they said they had 30 more pages for Jane Doe number 4 before they would move on to Nicole Edwards' direct and cross-examination.
All right, another extremely busy day inside that courtroom. Chanley Painter is with us. We got a lot more to talk about, folks. I'm going to bring in our think tank in just a little bit. But first, why don't you take a look at our 13th juror question? Should we take a look at that now? I think we should. And it all has to do with Jane Doe number 4. You know, the jury wants to hear testimony from Jane Doe number 4. They've been listening to it, the readback. Who do you think is better for, the prosecution or defense? It's an important question because this is coming from them. This is what they want. So I'm thinking it's a little better for the prosecution, but nobody else is agreeing with me. How about you?
I'm Julie Grant. As a lawyer, I'm an officer of the court. As a prosecutor, I represented the people. Now on CourtTV, I represent you.
You have to look at everything in this case.
Because it's my job to bring you the whole truth and nothing but the truth.
The all-new CourtTV, your front row seat to justice.
Big breaking news out of San Diego, California in the Kellen Winslow trial. The jury asking for more information. They wanted to hear from Jane Doe number 4 again. Now, what does all this mean? How important is this? What does this tell us about this jury? First thing it tells us about this jury is they're taking their jobs very seriously, number 1, right? Number 2, there's some debate taking place inside that jury room. Because if they all agreed, they could very easily just take a vote and be done with it, one way or the other. That's not happening. It's not a quick verdict, because now they are done for the day. But the fact that they wanted to hear from one of the accusers again and her friend is big. As a matter of fact, it was the biggest moment of the day.
All 12 jurors are present. Again, Mr. Winslow and all counsel are present. I received jury note number 2, signed by juror number 6. Are you the foreperson? Yes? Okay, so the note reads, can we please get a readback of Jane Doe number 4's testimony as well as Nicole Edwards' testimony? Then it says also we are missing exhibit number 154. Can we please get that? So I've called you into open court here today for a couple reasons. We're going to address the note, but before I do that, I want to, I know I've told you this several times, but now is very critical. You have to avoid all media contact. Don't watch any media accounts of this. As you can imagine, there's a lot of anxiety about the verdict, and there's people commenting on it. It's very important at this crucial stage that you avoid reading anything or watching any coverage whatsoever. Also, if you become aware of any other juror that happens to be watching something or they talk about some news coverage they saw, you have to bring that to the court's attention as well. So please be extra vigilant. I know you have been throughout the course of the trial, but at this point it's extremely important that you stand by that admonishment. All right, first of all, with respect to exhibit number 154, that exhibit was marked and it was discussed, but it was not received in evidence. So I know in the note you said you're missing it. It was not an error. It does not go back into the jury room. There was some discussion about what was said, and that's a printout of the text messages. So you don't actually get the printout, but there was testimony about the printout, and that is certainly admissible. And you're going to hear the readback regarding both Jane Doe number 4 and Nicole Edwards, where they discussed the contents of exhibit number 154, but that exhibit did not go back into evidence and you will not be receiving it. Now, with respect to the readback, the court reporter, Stephanie, has gone through the transcript. I know we were going to start at 1:30, but it took a little more time than she thought it would, and she worked through lunch getting the transcript ready to go. So I apologize for the slight delay, but we want to make sure that everything is in order before we read it back to you. That includes removing any testimony that was stricken. If it was stricken, we don't want to read it back to you during readback. So as I said before, it takes a long time to get it ready. But Stephanie is ready with the readback. We will read back first the testimony from Jane Doe number 4. Stephanie will read straight through. She's going to read all of the testimony, which will include the direct and cross-examination and any redirect or recross, and then she will do the same for Nicole Edwards' testimony. It's important that you not discuss the case with each other during the readback. During readback, you are only to listen. You can't talk about it with each other because you can only deliberate when the 12 of you are together back in the jury room and only in the jury room. So as I said before, even if all 12 of you go to lunch, you can't talk about the case because you're not in the jury room and you're not in a quiet place. So that includes the courtroom. You cannot deliberate while you're here. You cannot discuss the case with each other at this time either. So what we're going to do now is I will go off the record, and Stephanie will begin by reading Jane Doe number 4's testimony, followed by Nicole Edwards. All right, anything from the people at this point, Mr. Owens? No, anything from the defense? All right, then we will go off the record, and Stephanie will begin to read back.
And that's what happened today. The testimony of Jane Doe number 4 was read back to the jury. Inside the courtroom was our own legal correspondent, Chanley Painter, who joins us now from outside that courthouse. So, Chanley, first question, the lawyers, either side feeling a little bit better tonight because of this readback?
Well, they were probably seeing the same things I was seeing from the jury, what they seemed to be interested in, and that was more of the direct testimony of Jane Doe number 4 so far, but they haven't yet listened to Nicole Edwards. We'll see what they're interested in for Nicole Edwards, but all the attorneys were there. I know that Mark Carlos mentioned early on, we have to travel in 45-50 minutes. It may only be one of us here if there's something that needs to be done, but all three, Mark Carlos, Brian Watkins, and Emily Barr, were present along with Kellen Winslow II at the defense table, and Dan Owens was sitting solo at the prosecution's table while all of this went down just moments ago.
All right, Chanley, so as you mentioned, they're taking a lot of notes when the testimony was being read back about the incident and during direct examination. They had asked for a printout of the text messages. There was also some testimony about those text messages. What was that moment like during the readback?
I was paying attention because they can't see the exhibit anymore. It was stricken from the record, taken off. So there is testimony about this text message exchange, and when it did refer to number 154, the jury was taking notes, and at certain points what was said, what was asked, what was answered for those text messages. So they were noting all of that, and who knows what they were wanting, but it has to do with when Jane Doe number 4 told her friend Nikki Edwards about seeing Kellen Winslow on the news and how it was making her feel at the time, very upset, and why she wanted to come forward, her husband encouraging her to come forward, all of that. And so then maybe that's why they want to also hear Nicole Edwards' testimony tomorrow.
And how about the body language from this jury? It was a long day. Now, our jury clock is over 12 hours. How are they looking and feeling?
They seem pretty exhausted to me. As they sit in the jury box, it was a little bit different from formal court. As we've been seeing them over the past couple of weeks, they seemed a little more laid back and informal, sitting in their chairs, slouching over, leaning over, turning around this way or that way, while either taking notes or listening intently to what the court reporter was saying. But it was very clear how they were intensely, almost ferociously taking notes throughout the description of the incident, and then would kind of sit back and relax, and not as many people taking notes or sitting up in their chair as cross-examination and other details were described from the court reporter's report.
All right, Chanley, time for me to break out the tea leaves. Going to bring in my think tank, who's got to read those leaves for us tonight. Joining us here in studio, we've got Barbara Moon, criminal defense attorney, Lance LaRusso, criminal defense attorney, former law enforcement officer, and Ashley McMahan, criminal defense attorney. All right, let's start reading them, okay? They're taking a lot of notes during the direct examination.
This is what's so great about CourtTV. We've got Chanley sitting in the courtroom doing exactly what all of us would be doing in the courtroom as the attorneys, watching the reactions of the jurors. And she clearly said that juror number 12 was the only one who came out and made eye contact with the defendant. And then she said juror number 12 and juror number 2 were the only ones furiously taking notes when they played back the cross-examination of Jane Doe number 4. I'm thinking we're deliberating so long because there's a holdout, maybe more than one. And if I was going to place bets on it or read the tea leaves, as you said, I'm betting it's juror number 12 and number 2 they're holding out for the defense.
Barbara.
It could be number 6, the foreman. And that because his background is he's in a management position, and that he's strong in his position, every which way he's going. It would concern me as a defense attorney because he has the police background. No offense. But that would concern me. And if he's like pointing out certain things from a police standpoint or his background. That would really concern me if some jurors have different opinions, that he is saying, well, wait a minute, what about what Jane Doe number 4 said? And then if there's a disagreement, they're saying, well, okay, well, I'll tell you how we resolve that. Let's play it back. And then Nicole supports that. And let's see what she has to say. It's very interesting that they also want Nicole's testimony.
Absolutely.
So I
absolutely.
think that's huge, huge.
Lance, what are your thoughts about the fact they're taking more notes? Most of them are taking more notes during the direct readback versus the cross readback.
I actually think that says a lot for the prosecution. I think they're trying to listen to some key fact that was brought out by the prosecution and paying less attention to some hole that might have been pushed in it by the defense. You know, when you look at people getting together, people of a like mind, people who are paying attention, may miss something. They may hear something differently. So I think that sometimes we can attract or we can put too much emphasis on the fact that they wanted to hear from one person's readback. They could have made a decision on every other count. I mean, there's 12 counts in this indictment. So they have a lot to absorb. That's a lot of information. And, you know, as much as people make fun of juries and say, oh, it's a terrible system, in my experience, they try to get it right. They may get it wrong, but they really take it seriously. And it could just have been, hey, we have a chance to listen to this again. Let's go sit in there and listen to it.
RJ, all night I've been saying this is better for the prosecution. You've been disagreeing with me all night. Do you still disagree based upon what Chanley now has told us about what was happening inside?
I think, are you speaking to me, Vinnie?
Absolutely.
I think that I think I agree with your panel guests. I think the leader in this case, the foreperson, has the strongest personality. He's a COO. He knows a former law enforcement officer or is friends with a former law enforcement officer. I think is going to be analytical, and I think they're going to be looking to his guidance. So I think the foreperson, in my opinion, doing 70-plus trials in my career, usually could tip the scale in one way or the other. So I think that what I know about the foreperson, I think is going to be critical on Jane Doe number 1. I think it's going to be critical on Jane number 2. Whether or not he's going to find guilt as far as the forcible rape on number 1 and number 2, I don't know. But I'm pretty confident that there's not enough evidence to find him guilty on the kidnapping on Jane Doe number 1. Whether or not there was forcible rape on Jane number 2, I don't know. Jane on 3, 4, 5, that remains to be seen.
All right. Well, today was all about Jane Doe number 4. Now, the fact that they asked for this before lunch and then they had their lunch and then came back and this is all they heard, do you think they talked about anyone else today? Is it possible?
It appears like they're going in order. And the reason I'm saying that is because yesterday, number 3, they asked for information on number 3. And it was the, I think the geographical area of where number 3 lived and where he was riding his bike. And so because of what they asked for yesterday, in my opinion, it looks like they're going in order of the Jane Does. And so if they're on Jane Doe 4 number today, and they finish with the testimony tomorrow reading, it does seem like they're focused on the direct, which tells me they're focused on it from the prosecution standpoint. Then if they finish that tomorrow, they just may wipe their hands up and say, let's go to number 5. And I'm thinking we're going to have a verdict tomorrow.
Well, you know, the judge asked them, could they continue to deliberate? So if they were completely locked up on everything without hearing that testimony, they would have said no. They clearly said we can go back and deliberate and we'll just wait and fill those holes in later. So I think they're clearly talking about the entire case as a whole and maybe looking for more specifics from that one victim.
All right, our 13th juror question. The jury wants to hear the testimony of Jane Doe number 4 again. Is that better for the prosecution, like I've been saying, or the defense, like everyone else is saying?
When you were telling him to stop and pressing your hands against his thighs, were you trying to make him stop having sex with you?
Yes.
Did he continue to penetrate you vaginally with his penis from behind?
Yes.
Do you remember if he said anything while you were telling him to stop?
No.
What did Matt do as you were telling Kellen, Mr. Winslow, to stop and pushing against him?
Matt got up and was telling him to just stop. And then Kellen flipped me onto my back.
When you say that Kellen flipped you onto his back, how did he do that?
He turned me over So he turns me over, I don't know which way, but I'm now laying on my back on the bed.
The dramatic testimony of Jane Doe number 4, some of the most emotional testimony throughout this 2-week trial where 5 different accusers took the witness stand. But of all 5, Jane Doe number 4 clearly was the most emotional while she was testifying. Well, today the jury wanted that testimony, they wanted to hear it again. So they didn't bring Jane Doe 4 back. What they do is they read the testimony. The court reporter goes through it line by line, reading it to the jury, and they went through most of it today. They will finish tomorrow morning. But in the meantime, they asked for it, they got it today, and as Chanley Painter told us, they were taking notes most heavily during the portion where she's describing what happened to her, that part that we just played for you. Bring back in my think tank. To me, the emotion of Jane Doe number 4 was something that didn't necessarily exist for the other accusers. And each one told their story much differently, different people, different walks of life, different time of their life. What do you think about the fact that the most emotional one is the one that they're listening to again in a very unemotional way, as it's just read like this, like the way the court reporter is supposed to read it?
Well, I think it's an absolute shame for the prosecution that, they weren't allowed to see her testimony again because, as you said, it was by far the most emotional testimony that we saw. And the dry read back, I mean, God bless that court reporter, but the dry read back just does not have the same effect. But clearly the jurors are looking for some specific fact that she mentioned or that they thought they heard, or maybe that they're arguing over whether or not they thought they heard something during her testimony, and having the entire direct and cross-examination read back to them. We'll just have to wait and figure out what it is.
Now, the other thing about her testimony and the witnesses who tried to support her testimony, the prosecution tried to use to support her testimony, different accounts. You had a police officer who said that she told him a slightly different story, and it changes a little bit. Could it be possible that they know what the other people said and they're trying to remember what she said and trying to see if there is a huge discrepancy between the accounts?
It could be, but she is, and I was at first, when I knew that some background on her, I thought, well, the distance, from the time that she came forward. And I was thinking that she came forward because maybe publicity, maybe a potential lawsuit down the road. But then when I started hearing her testimony, and it was so emotional, to me it was kind of bizarre because hers was the longest time period that something had happened to her, but yet she was more emotional than the others who were more recent, a year ago in 2018, and hers was back in 2003. And she was emotional through her entire testimony, just Kleenex after Kleenex. And so to me, it was the most compelling testimony and the most emotional. And if there's, I think, 4 women on the jury, if they're, feeling the same emotions, and they may say, what, that really bothers me, even though it was 2003 when this occurred. Yeah. I want to hear this again, because that stays with you, those emotions, because the others that they just kind of talked about it, and especially number 1, who was a real train wreck.
Yeah, it didn't work out well for prosecutors, and they tried their best, and they may be successful here. The read back is just what she said,
right? But
when she testified, it was how she said it.
Yeah.
So how do we reconcile that for the jury? I mean, do you think they already know that, they felt that, so they just needed to hear the words again?
I think a jury can hang on an inconsistency among witnesses, as you talked about. Everybody can. But I think, there's an old saying that the truth fairly told has ragged edges. You can't expect that 4 people testifying about something are going to match up exactly, and sometimes if they do, that's less credibility. I think the emotion goes for the prosecution. I think the emotion goes for her credibility, because if somebody has kept this inside them for so long, those text messages give the answer as to why. He's locked up. And over again, the text messages are, I'm glad he's locked up, he won't hurt anyone. And implicit in that, when any victim is, now it's okay for me to tell my story because he can't hurt me.
RJ, is it possible that it could be a money grab with Jane Doe number 4 and yet testify the way she did?
I think it's definitely a money grab. I think it's a money grab because she waited so long. She watched CourtTV. She watched the news and she saw that this was being investigated against Mr. Winslow. And I think the prosecution, frankly, is bootstrapping Jane Doe number 4's testimony to bolster Jane Doe number 1 and Jane number 2's testimony, because their testimony fell
One question
flat.
though, how do you
So I
how do you
think
explain
that
the emotion? The emotion of it is this play acting? Is she misremembering it? Is she making it up and she's just really good at putting herself in the shoes of a 17-year-old who's just confused? What exactly? Did she lie?
Well, she was drunk, 17. Maybe there was a threesome that she regretted and that she had ill feelings about. And there's a lot of things that could have happened. And that's the problem with bringing these things years and years and years later. Perhaps she was embarrassed of what she happened. Perhaps something happened that she didn't want. But that doesn't mean that Kellen Winslow and his friend Mark were raping her. And by the way, if that was rape, why isn't Mark being charged with a crime, his friend? Isn't that something that the jury's going to consider?
Yeah, and that's something we've been talking about here on Court TV. And you said Mark, I believe his name was Matt. Was the third person who was in the room while she was unconscious and he was naked on the bed and all of that. But he wasn't called, or we don't believe he was investigated either by the prosecution.
The jury has been instructed to ignore that.
And clearly has not been called by the defense either. Lance, so what were your thoughts there?
There's a jury instruction that says they can't consider whether or not the other person was charged or not. They have to look at the person who's on trial right now, and the matters of whether the prosecutor's charged him, whether he was able to be charged, what happened to those charges. They've been told in those instructions to disregard that and not consider it.
Yes, but you can tell a jury all day long to disregard something, and once the cat's out of the bag, the cat's out of the bag. I agree with RJ in this case. I think that it looks really bad for the prosecution that they're not also charging the other guy who was involved in this alleged incident that happened in 2003.
Because he's a witness, supposedly. He is a witness to this offense. He's part of it. And I think the prosecution did not call him because he's part of it. And they're wondering, even though they have this jury charge, why is he not here? Why is he not testifying to support Jane Doe's position that this happened?
Yeah, and his position is really unique in terms of the way it was described by Jane Doe number 4. On the one hand, this guy Matt is naked on the bed. Kellen Winslow, according to Jane Doe number 4, raping her. She's unconscious. When she regains consciousness, her head is pressed into the midsection of this naked guy named Matt. So that's not legal, folks. I can tell you that much. But then later on, once she says stop, he's the one, Matt, who then takes action to get Kellen Winslow to stop the rape, according to the testimony of Jane Doe number 4. So it really was a very unique position that his testimony would have been in. On the one hand, there's an argument that he's committing a rape, and then there's an argument that he's the hero that stops the rape. So both sides declined to call him, but the thing that did surprise me is that he was not even investigated or interviewed by prosecutors in this case. Our 13th juror question. The jury wanting to hear the testimony of Jane Doe number 4 again. Is that better for the prosecution or better for the defense? Go to our Facebook page, our handle, CourtTV.
CourtTV has returned to television,
bringing you the cases that change our world.
My client is on trial here for his life.
With live gavel-to-gavel trial coverage from across America.
You'll be there for every compelling moment.
Did you lie to the detective?
Can keep my life straight.
as history unfolds.
Guilty of first-degree murder.
Emotions rise, and justice is served.
The all-new Court TV, your front row seat to justice.
Jane Doe 4 was 17 in 2003 when she says a then 19-year-old Winslow assaulted her while she was passed out from drinking. She told police she knew it was Winslow because he was a well-known college football player and she had a consensual sexual encounter the first time they met. Jane Doe 4 says when she woke up during the alleged assault, she told Winslow no and told him to stop, which he did not do. She came forward after finding out Winslow had been arrested for sexual assault.
Why would anybody believe me?
Other than talking to Nicole about what had happened, did you tell anybody else here in San Diego before moving to Hawaii?
No.
Why not?
Because I think nobody would have believed me. They would have, you know, in your mind, you're kind of like, did you allow yourself to go in that situation?
Is that how you felt?
Yes.
Well, you say no, 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 no. Right?
I say stop.
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 Okay. And that's what you recall, saying stop.
Yes.
And then you push against him, the way you described it, you pushed against him with the palms of your hand backwards on his thighs.
Yes.
So with both hands?
With both of my hands.
So did you then lie face down?
Yes.
Do that?
So my face is now against the bed, and my hands pushing against his thighs.
Okay.
Who's the person who's going to remember the details? The rape victim. Who's going to know what actually happened on the 2 interactions she had with this man? Not her friend who's being asked about it 16 years later. Her. Was she lying to you based on some motive? Based on some incentive to try to really get this guy that she hadn't had any interaction with for the last 15 years? That's unreasonable, and you can reject that argument.
She decides she's going to call the police. I'm going to call them. I'm going to call law enforcement, and I am going to relate what happened to me. Right? Now, this is really, really, really important because the prosecution doesn't even want to address it. They didn't do it in their direct, and I challenge them to say something on the rebuttal about this because they know what it means. Because Jane Doe 4 had the opportunity to think about what she was going to say. She had 15 years to think about what she was going to say.
Jane Doe number 4 taking center stage once again out in San Diego today. The jury wanted to hear her testimony again, so there was a readback. Remember, 2 counts of involving Jane Doe number 4 against Kellen Winslow II. Count 7, forcible rape, and count 8, rape of an unconscious person. Now, Chanley Painter reported to us that during the readback, the part when they were taking the most notes, the jury, was when she was describing what had happened. Let's take another listen to that part of the testimony.
What happened after you were looking at the fabric on the couch?
I opened my eyes and my face was being pushed into Matt's groin area.
Prior to that memory of opening your eyes, do you know what happened while you were on the couch down in the downstairs area of the town hall?
No.
Do you know if you fell asleep?
No.
Were you conscious between when you were on the couch to when you felt yourself being pushed into Matt's groin area?
No.
Do you know how you got from the couch to the place where your face was being pushed in Matt's groin area?
No.
Where were you when you woke up to that, or when you came to?
Is it a bedroom? On a bed?
Do you remember if that was upstairs or downstairs?
I don't know. I don't remember.
Do you know how you got from the couch to the bedroom being on a bed?
No.
When you say that your face was being pushed into Matt's groin area, who was pushing you?
Kellen.
How was Mr. Winslow pushing you into Matt's groin area?
From behind.
Do you remember what part of his body he was using to push your face into Matt's area?
His hand.
Where was he pushing you with his hand?
His hand was on the back of my head.
And Your Honor, for the record, she's taken her right hand and placed it on the back of her head with an open palm pressing downward.
The record will still reflect.
Excuse me, Your Honor, we have exhibit 4 taken down. It's not being used.
All right, we can black out that exhibit.
Thank you.
Next question.
Thank you, Your Honor. Now, what was Kellen doing at the time that he was pressing your head towards Matt's groin area?
He was penetrating me from behind.
Was he having sex with you?
Yes.
Was he having sex with you at the time that you regained consciousness?
Yes.
And I'm sorry to ask you, but how was it that he was having sex with you? Where?
He was, I'm sorry,
What part of his body was penetrating what part of your body?
His penis was penetrating my vagina.
When you were on the bed, you mentioned that he was doing this from behind, is that right?
Yes.
Was Matt lying on the bed?
Yes.
When you say that Kellen was having sex with you from behind, pushing your head towards Matt's groin, was Matt's penis exposed?
Yes.
Did he have his pants off?
Yes.
Did you have any memory prior to waking up to this happening?
No.
What was Matt doing?
Matt was just laying there with his legs open.
Were you facing him?
Yes.
What was Kellen saying, if anything, at that point?
I don't remember. I can't. The only thing it's just my view. I don't hear anything.
What did you do when you regained consciousness and felt Mr. Winslow doing this to you?
I'm telling him to stop.
Did you actually say that out loud?
Yes.
Do you remember what you said when you were telling him to stop?
Just stop. Just stop.
Did you become upset?
Yes.
Were you crying? If you know?
Yes.
And you know, I keep coming back to the way she testified, Jane Doe number 4, because I think for most of us that has followed this trial have seen 5 very different Jane Doe number 5s, 1 through 5. I mean, all very different in terms of the where they come from in life, who they are, the way they speak, and the way they've reacted to what they say happened to them. But this was the one above all the rest that you would kind of expect, right? This is the way they would testify if you're watching an episode of Law & Order SVU. I mean, this is what you expect. I'm not saying the other ones aren't legitimate, it's just different than what the stereotype is. RJ Manuelian is with us. He's outside the courthouse in San Diego. RJ, give me and the viewers some perspective on this, because you're in courtrooms every day. Do sex victims, sex offense victims, do they generally testify emotionally like Jane Doe number 4, or are they all over the map the way these 5 Jane Does have been during the course of this trial?
From my experience, based on doing this almost 20 years, most of the victims testify like Jane Doe number 4. They're embarrassed, they're sad, they're nervous, they can't remember what happened, they're very emotional. Nothing like Jane number 1 or Jane number 2. So I think that Jane number 4 really bolsters the prosecution's case and perhaps even helps Jane number 1, Doe number 1 and Jane number 2, their testimony as well.
What do you think? Do you think there's an opportunity here, Barbara, that the fact that she testifies that way and the others didn't, that the others become less credible in front of this jury, that their accusations become more questionable?
Not necessarily, because her emotions really captivates you so much that you start thinking, wow, you know, maybe number 1 and number 2 just do not have the same personality because there's an age difference. She's younger, they're older, and maybe they think, well, because they're more mature. Also, Jane Doe number 4 is talking about she has 2 little girls. She may be bringing that in the picture. I don't ever want this to happen to them. And so she's more emotional, but I don't think they're going to hold it against 1 and 2. I just think Jane Doe number 4's case is stronger because the way that 1 and 2, they reacted to the testimony. Number 1 was just, again, a train wreck.
Yeah, and you know, Jane Doe number 1, you know, a bit was a hitchhiker. She was picked up as a hitchhiker. Jane Doe number 2, homeless, but she was much different than 1. And she had really difficulty just catching her breath on the stand. So that was a contrast. But there wasn't the outward sobbing that we got here. I mean, Jane Doe number 4 takes us there. through her testimony.
She's sobbing constantly. I mean, she's grabbing Kleenex after Kleenex. And you start focusing on that, thinking, this is sad, because when it first started, I had a totally different point of view just because of the distance. And then when I started listening to her, and you really start feeling her emotions. So I think that she's the strongest for the prosecution.
And the fact that there are, oh, you're going to say something, go ahead.
Yeah, well, there's no denying that we're having this trial during the Me Too movement. And if you notice during defense counsel's closing argument, he was very careful, because Jane Doe number 4's testimony was so emotional, not to call her a liar. He didn't use the word liar one time. Instead, he said she had 15 years to come up with this story or to get her facts straight. And then the prosecution, in their closing argument, said, basically dared the jury to call Jane Doe number 4 a liar. So, I mean, I think we're working with two different strategies here, wildly different strategies, and you have to keep in consideration that a jury is going to buck up during the Me Too movement if they're going to hear a defense counsel say, hey, you need to call this woman a liar simply because this happened so long ago.
And Lance, if this really was a money grab, right? Why not go after the money when he signs the big contract when he's a football player, right? Because she reads the news. She knew that he got drafted in the first round by the Cleveland Browns, and his career sort of followed. The guy ended up making $40 million. I don't know how much he has left at this point after paying the lawyers and whatever sort of lifestyle he's had. But why not back then?
Well, and why not just keep it in a civil context? Why would somebody go through what she's gone through? And, I was a street cop, and I was also an investigator for a prosecutor's office. They have gone through her background. They know what questions are going to be asked. They've looked at any obvious signs that she is doing the money grab. And it's dangerous. I think one of the reasons they replayed her testimony, the rape of an unconscious person, and if you look at the jury charge, it's really interesting. It's an anomaly in the law, because you're basically saying to someone, a violent attack occurred to you, and it was a violent attack and against the law because you were unconscious, but you have to presume that this unconscious person cannot tell you exactly what happened. That's a very, very difficult thing for the lay person to realize. So I've got to have proof the person's unconscious, but then they can't testify about the facts of it. So that may be why they wanted to hear it. That's why the prosecution very correctly brought out, you don't know how you got from the couch to the bed. You awoke to this happening. And if you notice, he doesn't talk about a change in position or a change in actions. That situation was going on as she awoke. So that may be one of the reasons why they honed in on number 4, especially if they've got a copy of the jury charges.
They've got them. They've got them. I've got them right here. 50 pages worth, and they've got them in the jury room.
And also in the beginning, too, there was one who said, when it first happened, one of the males, who said to her, you can't talk about this because you'll ruin his career, or something to that effect. So then if she did not know who he was, when it did happen to her, she knew it right after, and she could have gone after the money then.
Absolutely.